Yes, my lord, the counsel are in court. Announce your appearance, counsel.
Due receipt, my Lord ML Abdullahi, apparent all the defendants.
Abdullah, you are present in court.
Yes, my lord. Yes, my lord. I'm before the court.
My lord, he's in the courtroom.
Just hold on. We are trying to sort out this issue with the device.
As court pleases, my lord.
So, ML Abdullahi. Is it ML Abdullahi?
Yes, my lord. Apparent for all the defendants.
Okay. How about the claimant's counsel?
Yes, my lord, the claimant counsel, even today in the morning, we communicate with him. He said he is on his way, and he asked me to send him the code, and I sent him the code.
Okay, he's aware of today's date anyway.
Yes, very much sure, my lord.
All right, thank you. So the court will proceed. The matter is for judgment, and the court will proceed to deliver the judgment.
As court pleases, my lord.
All right, so I'll proceed with the judgment. I don't know why this thing is not showing. The claimant's complaint is dated and filed 21st day of May 2019 and accompanied with claimant. Please, can we just mute our devices so that we can take the judgment? Please, can we mute our devices so that we can take this judgment?
As court pleases, my lord. Mute your devices. Silent.
The claimant's complaint is dated and filed 21st May 2019 and accompanied with claimant's originating processes, filed in accordance with the rules of this court, with the following claims against the defendants. Declarations that the claimant is entitled to all his accrued remuneration, salaries, furniture allowances, vehicle maintenance allowances, etc., purchased in his name in accordance with the terms of his appointment as commissioner in the service of first defendant, as stipulated in claimant's letter of appointment dated 19th August 2016, and the first defendant circular titled Revised Remuneration Package for Political, Public, and Judicial Office Holders in Zamfara State. 2. Declaration that the failure, refusal, or neglect by the defendants to withhold the claimant's accrued remuneration, salaries, etc., in his name is unlawful and constitutes a breach of the contract of service employment between claimant and first defendant, as contained in claimant's letter of appointment of 19th August 2016 and first defendant circular titled Revised Remuneration Package for Political, Public, and Judicial Office Holders in Zamfara State. 3. Mandatory order directing or compelling defendants by themselves, their agents, etc., to forthwith pay and or deliver to the claimant all the said salaries and allowances in his name, amounting to 36,815,557 naira 25 kobo only. 4. Interest on the said sum until judgment and thereafter at the rate of 21% until satisfaction thereof. And lastly, cost of action. In reply to the originating processes of the claimant, defendant filed statements of defense with accompanying processes filed on 17th October 2022, which were deemed proper on 9th December 2022. Prior to commencement of trial, parties adopted to settle this matter amicably to no avail, and matter was allowed to proceed accordingly with trial. Meanwhile, counsel to parties agreed in the course of proceedings of 5th July 2023 to have the trial done virtually, and trial commenced on 18th October 2023, when claimant testified that CW1 adopted his witness statement on oath of 21st May 2019, and documents tendered in evidence were admitted and marked SBC 1 to 11. Defendants, on the other hand, opened their case on same date after conclusion of evidence on CW1 and closed case on the same day with one Abubakar Mohammed, who testified on behalf of defendants as DW1 and adopted witness statement on note of 17th October 2022. The only document tendered in evidence by defendants was Exhibit 2024. The summary of the claimant's case is contained, and equally summary of the defendant's case. I will proceed with the final written addresses. The final written address of the defendant is dated 6 November 2023, filed 8 November 2023, while claimant's final written address is dated and filed 20th November 2023. The defendant has submitted two issues for determination: whether claimant is entitled to relief claim, and 2, whether Exhibit 1 to 10 tendered before the court and being a certified true copy of the originals have been duly certified or certificated by their custodian, thereby enabling claimant to prove his claim. So relied 99 in submitting that by above provision, the executive governor of the state is empowered to appoint persons to hold or act in offices to which this section applies. And went on to sub 2 of the section is that the council meeting whenever it's required to attend, and failure of which the executive governor that appointed him can fire him as he deemed necessary, and that it is not in dispute from paragraph C and F of claimant's statement of facts and witness statement or notes, which all point to the fact that the car loan and its maintenance allowance were loans to be given to claimants, which were subject to be deducted from his basic salary. He went on to define what is meant by loan, and referring to the Black's Law Dictionary 10th edition. It's all contained in the judgment. And finally relied on case of Guarantee Trust Bank PLC and Innocent Nigeria Limited. The citation is provided, wherein court defined debt and definition of debt as obligation to pay sum of money or other consideration arising from transaction, whether such obligation is present or future, obsolete or contingent, or whether such obligation is owed jointly or severally. He then submitted that claimant in the instant case is not entitled to the car loan, as state cannot stand for him as guarantor, urging court to resolve the first issue in favor of defendants. And on the second issue, counsel referred to exhibit C1 to 10, tendered before the court. And then cited section 131 sub 1 and 2 of Evidence Act 2011 to the effect that whosoever desires any court to give judgment as to any legal right or liability, depending on the existence of facts which he asserts, must prove those facts. He went on and reproduced subsection 2 of that section 131. Is captured in the judgment as well, and submitted the exhibits 1 to 10 being public documents and official records. The original counterpart is regularly being kept by a public officer authorized by law to keep or be the custodian of those records, and that by virtue of section 104 sub 1, 2, and 3 of the Evidence Act 2011, every public officer having custody of a public document which any person has a right to inspect shall give that person on demand a copy of it on payment of legal fees prescribed in that respect, together with a certificate written at the foot of such copy that it is a true copy of such document or part of it as the case may be. The certificate shall be dated and subscribed by such officer with his name and his official title, and shall be sealed. Whenever to make use of same and such copies so certified shall be called certified true copies. He went on to rely on case of BACO and FCDA and submitted that the personal assistant to SSG who happened to authenticate exhibit C1 to 10 is not the custodian of those documents and cannot effectively authenticate and certify them. Therefore, since the personal assistant to secretary to the state government is not the officer with custody, he cannot subscribe his name and designation on the exhibit and goes to render documents defective with lack of any probative value in the eyes of the law. He relied on Aliu and Namadi and equally section 104.1 Evidence Act, and that it makes it mandatory upon any public office having custody of any public document to charge a legal fee on demand for certification of those documents. That on a careful reading of the exhibit C1 to 10, the fee chargeable for certification of the public documents has been waived by the purported or alleged officer who certified C1 to 10, which contravened the provision of section 104.1 Evidence Act. Therefore, failure of claimant to pay the prescribed fee for the certification of the exhibit removed the probative value, urging court to hold and relying on Aliu and Namadi supra. He went on to submit the exhibit C1 tendered by the claimant during examination in chief, which CW1 denied under cross-examination of being the author, became a document. Became a document that was tendered in evidence through a witness other than the maker without proof before the Honorable Court, which established the fact that the maker of the said exhibit has been called as a witness before the court. Therefore, it goes to affect the probative value and weight to be ascribed to that document. He cited the OJ and FRN in support of his stance. According to counsel, exhibit C11 tendered before court contravene provision of section 84 subsection 2 and 4B of Evidence Act 2011, and that claimant must attach the certificate which contains the particulars of the device used in taking and producing the information. He relied on case of IGP and Bello, and that failure to state in exhibit C11 the particulars of device used in generating the statement of account domiciled in Guarantee Trust Bank and next to claimant's originating process subjected the claimant in precarious situations, speculative and conjecture as to which device was used. Therefore, exhibit C11 lacked probative value court cannot rely on same, urging the court to so hold. In conclusion, he submitted that the claimant, having fully failed to establish his claim vis-a-vis the defective exhibits 1 to 11 tendered before court, his claim must fail, and is not entitled to any allowances, including the car loan, etc. He relied on Alhaji Nuhu Ahmed and 7 others versus Kogi State Government. He then urged court to dismiss the suit with substantial cause as claimant has failed woefully to establish his claim. The claimant in his case formulates 3 issues for determination: whether or not a relationship of master and servant exists between claimant and first defender and the times on which that relationship is founded. 2, whether first defender is in breach of terms of employment between first defender and claimant. And lastly, whether claimant is entitled to relief sought. On the first issue, counsel referred to claimant's appointment letter of 19th August 2016, the acceptance of him as commissioner in the office of government of Zamfara State, and that the claimant served also in office of secretary to first defender and in the office of as a commissioner for higher education, and that he served diligently until he instituted his claim. According to counsel, that is claimant's counsel, defendants have impliedly admitted these facts, having failed in their joint statement of defense to deny or properly traverse him. And in reference to paragraphs 2, 4, 13 of a joint statement of defense, counsel to the claimant submitted that defendants had attempted to deny claimant the entitlement of the sundry allowances claimed for not being attendance of 12 executive council meetings held in the months of February, March, and April 2019. And that the claimant led evidence in the said paragraphs of his witness statement or note of 21st May 19 in proof of his pleadings, which were neither challenged nor contradicted under cross-examination by defense. That in further proof of the above first claimant tender Exhibit C1 and 2, and paragraph of Exhibit C1 expressly states that claimant was appointed a commissioner, while paragraph 2 incorporates the terms and conditions stated, enumerated in circular of 16th March 2007 titled Revised Remuneration Package for Political, Public, and Judicial Office Holders in the state, accompanying the main letter of appointment. He reproduced the opening paragraph of the circular. It is captured in the judgment as well. I think I may have to read it for better understanding of the judgment. Sequel to the receipt of the reports of the Revenue Mobilization, Allocation, and Fiscal Commission with regard to the revised remuneration, it recommended and was subsequently considered and approved by the House of Assembly in its sitting number 129 dated 7 March 2007 to revise the remuneration package, was informed by the need to keep pace with inflationary trend in the country, changes in the fundamental of Nigeria economy, GDP growth rate, modification of salaries and allowances, introduce new allowances that were not included in the old packages, correct placement of some categories of office holders who were wrongly placed in the old package, among other things. Following this development, I write to inform you that the state government has approved and adopted the following salary and fringe benefits in respect of different categories of officers mentioned in the report. Unquote. Counsel then referred the court to tables 1 and 2 and column 3 of circular on the basic salary and sundry allowances, etc., payable to officers in the category of secretary to the state government, head of service, and commissioners, that upon a cursory examination of the entries in the tables, it will show that the entries or content in the terms of salaries and allowances there tally with claim and evidence of claimant as deposed in paragraph 5 of statement or note of CW1. He reproduced the deposition of the claimant. It has also been captured in the judgment. According to counsel, these pieces of evidence remain unchallenged or uncontradicted during the hearing by the defense. He continued and referred the court to Exhibit C1 to 11, which defendants' counsel has urged the court to disregard for allegedly offending provisions of the Evidence Act. On objection of defendants regarding non-payment of fees for certification of exhibits, counsel drew the attention of court to the endorsement of fees waived, appearing in certificates endorsed on all the exhibits C1 to 9, relying on Section 1041 Evidence Act, which he has equally reproduced. submitted that from the underlying words of this section, it is clear the obligation to pay some fees for certification is dependent on the fact that a fee has been prescribed by the public officer for certification of a particular document. The person seeking certification of a document is, of course, not in a position to prescribe fee to be paid by him. That is a privilege of the certifying authority. It is against this background that counsel submitted that there is no obligation to pay fees where none has been prescribed and or where public officer waives payment of fees, as in this case. In the instant case, the public officer in custody of exhibit C129 chose expressly to waive payment of fees, a decision which must not be held to prejudice the rights of the claimant before the court. Counsel then urged the court to discountenance submissions of defense counsel and attach due weight to exhibits in the interest of justice. Again, he submitted that defendant's counsel in paragraph 3.6 of final address had objected that Director, Cabinet Affairs in Office of Secretary to State Government is the custodian of the exhibits and not the personal assistant to SSG. So claimant's counsel defense was attempting to give evidence under the guise of addressing the court that there is no evidence laid before court to the effect that the personal assistant to the Secretary to Government is neither in custody of exhibits nor authorized to certify them. Thus, address of counsel at this stage cannot be a substitute for necessary evidence. Hence, submission is without foundation and ought to be disregarded. Secondly, that the objection is misconceived that it does not advert to the provision of subsection 3 of 104 section of Evidence Act, which permits that any officer may be authorized to deliver certified true copies of public documents, but by virtue of which such officer is deemed to be in custody of the documents. That it is clear from the above provision that any officer may be authorized to deliver copies of public documents, and this is not exclusive to a Director of Cabinet Affairs in Office of into section C11 would show that particulars of the device by which the statement of account in exhibit was generated or produced are clearly stated therein, and that paragraph 2 of exhibit C11 stated thus: I quote, I certify further that the copies reproduced herein are reproduced from the HP computer with serial number quoted, which is connected to the bank's electronic data storage and retrieval system. That the court is therefore under a duty to accept the evidence of the claimant on this fact, to hold that there is a master-servant relationship between the first defendant and claimant, which relationship lasted till 21/5/19 when this claim was instituted before court, and that the terms of the said appointment are stated in the third column of the first table subtitled Annual Basis Salaries of the Executive State, and second table subtitled Revised Allowances of Executive State, appearing at page 2 of the circular accompanying the claimant's letter of appointment. On the second issue, which seeks to examine the propriety of the defendant's withholding salaries and sundry allowances of the claimant from the claimant's pleadings, the C1, by remitting salaries and allowances into bank, which is GTB, from his appointment in 2016 up to month of December 18, when defendant stopped. That since then nothing was remitted into claimant's bank account before his appointment expired naturally with the election of a new government. That after several demands made on the salaries, the defendant, who rather resorted to issuing the claimant with the query falsely accusing him of absenteeism from council meetings, and he relied on exhibit C3, 4, and 6. It is worthy of note that this query was issued only after, that's the submission of counsel, that the query was issued only after exhibit C3, 4, and 5, and written and served by defendants, and 5 months of withholding salaries and allowances. That exhibit C6 is obviously an afterthought. That defendants in their joint statement of defense admit that claimant's salary and sundry allowances were withheld by them, but sought to rationalize their action by alleging that it was in reaction to absenteeism of claimant from the council meetings. Counsel continued that the case of the defense, that the sundry allowances are mere privileges given, counsel then referred the court to paragraph 7 and 9 of witness statement or note of CW1 before the court, wherein claimant deposed that he attended his duties as commissioner diligently and without fail. This piece of evidence neither challenged nor contradicted by defense under cross-examination, and now left for defendant to allege otherwise to lead rebuttal evidence to show that claimant was not discharging his duties or responsibilities diligently. Claimant's counsel then referred the court to depositions of the claimant in the witness statement or note, deposition of the defendant in the witness statement or note, that is of DW1, and submitted that apart from the mere ipsi dixit of DW1 as contained in the above paragraphs, the defendants have not placed anything before the court to show that claimant was not attending the council meetings and functions. Evidence of defendants in above paragraphs not enough to satisfactorily rebut the evidence of CW1 and establish allegation of non-attendance of the meetings. He further referred court to paragraph 18 of witness statement or note of DW1, submitting that the evidence is inadmissible hearsay which must be disregarded. The evidence of DW1 suffers the same lack of credibility. He cited cases of Fatumbi and another versus Olanloye and others, and Nikole Awure and Iledu. To buttress his submission further, he relied on cases of Obudu and State, amongst other cases cited. From the foregoing, counsel submitted the evidence of CW1 that he had been attending meetings remains unchallenged and uncontroverted by defense. Then the pertinent question to answer at this point are whether, having regards to terms of appointment between claimant and first defendant, the first defendant has power to withhold payment of salary and allowances of claimant, and if yes, how is that power to be exercised? In answering above questions, he referred the court to Exhibit C1, that there is no term in Exhibit C1 which entitles the first defendant to withhold the payment of salaries and allowances of claimant while his employment is yet subsisting. That defendant sought to take refuge under the first defendant's guidelines on conduct of counsel's business, Exhibit D1, which is not part of the terms of employment applicable to claimant, not mentioned or incorporated therein. That it is right law that parties are bound by terms of contract which they willingly entered into, and that in construing or interpreting a contract of employment, the duty of court is to give effect to the intentions of the contracting parties as just. Thus, Exhibit D1 is irrelevant, must be disregarded in the resolution of issue under consideration. He cited NNPC and Aminu, amongst other cases, in aid of his argument. He went on and that assuming, but without so considering that D1 exhibit is relevant, what then is the effect of D1 on the employment of the claimant, which was just dumped on the court and without any reference to any aspect of the guidelines that affects the relationship? By implication, defendants are asking court to go on a voyage of discovery by wading through the pages and paragraphs of Exhibit D1 to find a term therein which entitles first defendant to withhold the salaries and allowances of claimant, which would amount. His further submissions that there is apparent breach of claimant's right to fair hearing as enshrined in section of the Constitution, and that defendant's decision to sanction claimant allegedly for absenteeism from council meetings and absconding from office are no doubt serious misconduct, if proved, and decision to withholding his salaries and allowances no doubt impacted the civil rights and obligations of claimant. Again, refer court to Exhibit C3, 4, and 5 as undenied claims, demands for settlement of accrued salaries, etc. And even that the answer to the query as contained in C7 was not given any consideration by defendants. Counsel reiterated that by the evidence of DW under cross defendants after receipt of Exhibit C7, therefore the effect of failure, refusal, or neglect by defendants to comply with the Constitution renders the decision to withhold the salaries unlawful null, void, and of no effect. He cited Wokoro and Onuma, amongst other cases, in urging of claimant. On the third issue, which seeks to examine the propriety granting release sought by claimant in circumstances of case, and the issue was also dealt with by defendant under issue 1 in their address. His submission here is that the defendant in paragraph 2 to 3, 2.3 to 6 of final address preferred arguments to support the right or power of governor of state to hire and fire at will. To cancel argument is misplaced or irrelevant in the claim, as the complaint before court is not that the claimant was wrongly fired or terminated, but the simple complaint of denial of claimant's accrued salaries and allowances while his employment subsisted. Counsel therefore urged court to disregard submissions of defendants' counsel in that regard has been misconceived. He again reiterated his earlier submissions in relation to issues 1 and 2 to the effect that claimant has satisfactorily demonstrated that at all material times between January to May 19, there was a subsisting contract of employment between the claimant and first defendant via the Exhibit C1 with the accompanying terms, which entitle him to being paid salaries and allowances at the scale or rate stipulated therein. He further relied on Exhibit C4, C5, 6, 7, 8, and 9 that these have demonstrated satisfactorily that defendants acted in breach of the express terms of Exhibit C1 and implied time of fair hearing guaranteed under Section 36(1) Constitution. That Exhibit C10, which is a statement of claimant's designated bank salary account for remittance of monthly salaries and allowances, shows no remittance from the second defendant. That by this evidence, claimant has discharged the burden of proof on him by virtue of sections 131 to 4 Evidence Act 2011, and in the absence of evidence from defendant satisfactorily rebutting or controverting the evidences led for claimant, this court has a bounden duty to grant all the relief sought since they are supported by evidence before the court. He further referred court to paragraphs 2.7 to 2.30 of final written address of defendants regarding car loan, which is one of the subclaims of claimant, and that this should not be granted, where defendants stated that it should not be granted because there's no legal basis for the loan, that the tenure of claimant has come to an end. In reaction, claimant counsel submitted that the grant of car loan, etc. to claimant is one of terms of contract of employment in Exhibit C1, freely entered into by claimant and first defendant, hence enforceable against defendant. Thus, all the relief sought by the claimant before court flow naturally from the finding that what the defendants did in withholding the claimant's salaries and allowances is in breach of the contract of employment in Exhibit C1 and the provision of the Constitution, particularly Section 36(1). Hence, a nullity. He urged court to so hold and resolve all the issues in favor of claimant and grant the relief sought against defendant. Now, the decision of the court. Having read the entirety of the processes filed by the parties, evidence adduced, and submissions made by counsel thereof, this court has arrived at a sole issue, which is the issue apt for determination thus. Whether from the entirety of the facts and evidence adduced before this court, the claimant has proved his case to be entitled to release claimed against the defendant in the suit. I've perused the release of the claimant before this court. He's seeking for declaration to the fact that he's entitled to the salaries and allowances as per annexure to Exhibit C1, which he has computed to be a total sum of 36,815,557.25 against the defendants in the suit. The annexure to Exhibit C1 is a revised remuneration package for political, public, and judicial office holders in the state, dated 16 March 2007. Exhibit C1 and its annexure is a circular with the reference number EXCO/26/volume1/144. I have equally perused paragraph 2 of the claimant's appointment letter of 19th August 2016, Exhibit C1, which the claimant has relied upon to the effect that he is to enjoy salary and fringe benefits in accordance with the terms and conditions of service as stated in the report of RMA FC as applicable in Zamfara State. It is not in dispute that the claimant served in the office of First Defender as a commissioner for higher education, see Exhibit C2 of 8th January 2018. It is obvious that the entire gamut of this case is centered around Exhibit C1 and its annexure. Thus, the question which is pertinent to be addressed is whether Exhibit C1 and 2, particularly Exhibit C1, will be applicable to the claimant to entitle him to the relief sought against the defendants in this suit. Before I proceed accordingly, I will address the objections of defendants regarding the admissibility in evidence of Exhibit C1 to 11. Defendants had in their final written address urged court to disregard Exhibit C1 to 10, that they are offensive to provision of Section 84, 104, sub 2 and 4 Evidence Act. It is the argument of defendant that it is the Director of Cabinet Affairs in office of Secretary to State Government in charge or in custody of Exhibit C1 to 10 that ought to certify the document and not the PA to the SSG, and that Exhibit C1 was not tendered through its maker and the fees were also waived. I've looked at Exhibit C1 to 9 regarding certification done vis-a-vis Section 104 Evidence Act 2011 as amended, which deals generally with certification of public documents. From the face of documents in issue, it is clear that defendants, as the custodian of the documents, did certify them in accordance with the provisions of the law. Regarding the payment of fees waived, it is my take here that it is not for the claimant to demand for payment of fees to be made or that same should be waived. Since defendant chose to waive the fees, defendants cannot use that against the claimant, and I so hold. More so, defendants did certify the document as being true copies. Again, defendants have not presented any evidence before the court to the effect that the personal assistant to SSG is not an officer authorized to certify Exhibit C1 to 9. See Sections 104, sub 1 and 3, Evidence Act, supra. It is right law that whoever procures a certified true copy of a public document is competent to tender such document and evidence in any proceedings in court without calling the public officer who has the custody of the public documents. Once a public document is certified and signed, as required by Section 104 of the Evidence Act, supra, such a document is admissible on its mere production, and it is unnecessary to prove custody or verify it. Thus, Section 104 of Evidence Act does not impose anybody on the public officer to tender such document. See Agagu and Daudu, an equally case of Dagash and Bulama. The citations are all provided. Therefore, arguments of defendant's counsel regarding Exhibit C1 to 9 are unsustainable and accordingly discountenanced. It is right law that the address of counsel cannot take the place of evidence. Consequently, Exhibit C1 to 9 are proper before the court, and I so hold. Next is Exhibit C10, bank statement of the claimant from Guaranty Trust Bank, Gusau branch, and C11, certificate of identification. Defendant's grounds is that the documents tender contravene provision of Section 84, sub 2 and 4B of the Evidence Act. I've again looked at the documents in issue and find that they were properly admitted in evidence, just as clearly stated by claimant's counsel in his address. C11XB contains the necessary particulars as required by law. See paragraph 2 of Exhibit C11. From the foregoing, I hold that Exhibit C10 to 11 were properly admitted by court in evidence and in accordance with provisions of the law. Consequently, objections of defendant's counsel regarding these documents are all hereby discountenanced. In dealing with the merits of the case, it's obvious from the pleadings of claimant and the relief sought that all that the claimant is praying from the court are his entitlements, which he alleged the defendants have denied him from the month of January 2019 to date for inexplicable cause. Civil suits, it is said, are decided upon preponderance of evidence. Thus, the burden of proving a fact lies on the party who asserts and is discharged by leading credible and legally admissible evidence in order to succeed. See Omishore and Aregbesola, Onovo and Mba, Section 131, 132, 133 Evidence Act 2011. In this case, the claimant's counsel has argued, even under cross-examination of CW1 regarding Exhibit C1 and 2 on its entitlements to allowances stated therein. Even the claimant's alleged absenteeism from his duties and responsibilities, therefore, claimant will be entitled. Above submissions of claimant may not be far from the truth. However, a claimant must prove his case through credible not rely on the weakness of defendant's case, even where the defendant did not lead any evidence. The does not alleviate the primary body of the claimant to prove his case. Accordingly, the claimant will not be entitled to judgment in its favor merely because the defendant failed to enter a defense. Or that the defendant's case is weak. The court is only bound to accept unchallenged evidence and credible. See Atunwa Aladenika, Ariwa Textile PLC, and Finetex, Action Congress of Nigeria and Iyako, and equally Healthcare Products Limited and Baza, amongst other cases cited. The citations are all provided. Upon a cursory examination of the evidence before me, it is clear that the claimant here served as commissioner in the office of the first defendant. See Exhibit C1 dated 19th August 2016. It is also observed that the claimant's claims for furniture and severance allowance, as claimed in his Relief 1, are hinged on pages 1 and 2 of annexure to Exhibit C1, dated 16 March 2007, and which, for the purpose of comprehension, are underlisted. 1. Letter titled Revised Remuneration Package for Political, Public, and Judicial Office Holders in the State. 2. Revised Allowances of the Executive State. It is deducible from the foregoing that the claimant's prayer 1 is based upon the provisions contained in the Certain Political, Public, and Judicial Office Holders Salaries and Allowances, etc. Amendment Act 2008, particularly Part 3 of the Act. Now, Section 6 of the Revenue Mobilization, Allocation, and Fiscal Commission Act, Cap R7, Laws of Federation 2004, which stipulates the powers of the Commission as regards remuneration, provides thus. 6 sub 1. The Commission shall have power to determine the remuneration appropriate to the holders of the offices as specified in Parts A and B of the first D schedule to this Act. Hereunder reproduced are Parts A and B of first schedule to the RMA-FC Act. I've reproduced same. Part A deals with the offices, the president, vice president, etc., all down to the Nigerian Police Council and Public Complaints Commission. The offices are so listed, and equally in Part B, the offices are so listed starting from the office of the governor, the deputy governor, chief judge of the state, and so on, the State Civil Service Commission, State Judicial Service Commission, and the State Local Government Service Commission, amongst others stated there. In addition, Section 32D, Item N, Part 1 of the third schedule of 1999 Constitution as amended provides thus. The Commission shall have the power to determine the remuneration appropriate for political office holders, including the president, vice president, governors, deputy governors, ministers, special advisors, legislators, and the holders of the offices mentioned in Section 84 and 124 of the Constitution. A cursory look at Sections 84 and 124 of the 1999 Constitution of Federal Republic of Nigeria as amended reveals that its provisions are in tandem with Section 6 of RMAFC Act. In this, Section 6 of the Revenue Mobilization, Allocation, and Fiscal Commission, as subsequently referred to as RMAFC Act, is a reproduction of Section 84 and 124 of the 1999 Constitution. These provisions are clear, therefore the literal rule of interpretation shall be employed. It follows, therefore, that Sections 32D, 84 and 124 of the Constitution as amended, and 6 sub 1D of Revenue Mobilization, Allocation, and Fiscal Commission Act does not recognize the office held by the claimant as public office or political office holder whose salary and emolument shall be fixed by the RMAFC, such as Wokedi and Anambra State Government and another. Thus, RMAFC Act constitutional and ultra vires when it made provisions for allowances and free benefits for the claimant, in this case, via the circular of 16 March 2007, under the title Revised Remuneration Package for Political, Public, and Judicial Office Holders in the states, Zamfara State, and I so hold. Now, the courts, in line with Section 1 of the Constitution, have consistently held that the Constitution is supreme and provision shall have binding force on all authorities and persons throughout the Federal Republic of Nigeria. More so, Section 1(3) of Constitution further provides that where any other law is inconsistent with provision of the Constitution, Constitution shall prevail, and that other law shall, to that extent of inconsistency, be void. See the case of Maro and others versus Iyako and others. Accordingly, the certain political, public, and judicial office holders salaries allowances amendment of 2008 to the extent of its inconsistency with the Constitution is null and void, and I so hold. I cited again case of Charles Wokede and Anambra State Government Supra. Consequent upon the above, it suffices to say that the claimant here is not entitled to relief sought against defendants in the suit. Implication here is that the claimant, having failed in his relief 1, which is his main relief, addressing the other reliefs 2, 3, 4, and 5 will be tantamount to an academic exercise, which the court has established that it will not indulge itself in the luxury of same. Reliefs 2, 3, 4, and 5 all fail as they cannot stand on nothing. See Bojwani and equally USA and Markford. There are certain party, that is claimant hearing, must adduce evidence so cogent and credible to succeed in his reliefs against defendants in suit, which he has failed to do. See MTN Communication Limited and Outer. Citation is provided. It is my firm view, thus, that SBC 1 and 2 cannot on their own prove the case of the claimant to entitle him to the reliefs as sought in the action. Again, claimant's reliefs 1 and 2 are declaratory in nature, and the burden of proof on the claimant in establishing declaratory reliefs to the satisfaction of the court is quite heavy, in the sense that such declaratory reliefs are not granted even on admission by defendants. See Adan Ubandawaki, citation provided. Having held that the RMAFC acted unconstitutionally and benefits of the claimant hearing by the circular of 16 March 2007 under the title Revised Remuneration Package for Political, Public, and Judicial Office Holders in State, Zamfara State, claimant in effect is not entitled to the salaries and severance allowance, etc., as claimed in the suit and contained in annexure to Exhibit C1, and I so hold. Flowing from all that have been said above, the loan issue is resolved against the claimant and the suit is hereby dismissed. Judgment is entered accordingly.
Thank you, my lord. We are most grateful, my lord, for your erudite judgment and well-reserved honor. Thank you, my lord.
You're welcome. Yes, Gidado, call the next case, please. I'm not using this. Call the next case.
NICN/SK/02/2019. Mr. John Inyaigu, First on Basis Corporate Project and Resources Limited. My lord, parties absent.
How about the council? Any council?
One of the council, my lord, he has sent a text. He has a matter before Court of Appeal, and I forwarded the message to Bashma.
So you let which council is that?
Omora,
that's the claimant council. How about defendant's council?
Yes, my lord. Omora is the defendant counsel, my lord.
Yes, how about defendant's counsel?
No, the claimant counsel there, my lord.
Please, which counsel is present in court or online?
I think none of them, my lord. The last issue is that the claimant here is he came here for the last sitting. When he was in the court here, there is one lawyer appeared there in Abuja physically before the court.
So no counsel is present. I can't see any counsel. Yes?
Yes, and they have
right,
filed processes there in Abuja for final written address, and they did not send any copy to us here to serve the claimant. So we discussed with Bashma yesterday.
Okay, the claimant has not been served.
Yes, the process was filed there in Abuja, and we did not even aware of the filing or of any processes before the court, my lord.
All right. So we'll consider another date. Look for another.
As God pleases, my lord. June. We have 5th June.
What dates do you have? Yeah, what date?
Yeah, we have 5th June, my lord.
What date do you have there, Gidado, for Sokoto?
5th June, my lord.
Let's check the diary here. Is it 5th or 15th?
5th June, my lord.
Okay, 5th June.
Yes.
This will be for adoption.
As God pleases, my lord.
Yes, so we'll take that date if it's for adoption. Yes, so let's so the case is adjourned to 5th June 2024 for adoption of final written addresses.
As God pleases, my lord.
So hearing notice shall be served on all the parties.
As God pleases, my lord.
So you have to find a way to serve yes, hearing notice to the and the service of the
And the council are there in Abuja, my lord.
okay, the council they're in Abuja. Okay, so I think service will be affected then on the it's Kebbi. Yes, the service here is saying Kebbi. Anyway, the registrar, court registrar, we saw that out with the registrar in Sokoto division after the sitting.
As God pleases, my lord.
Service of the process, that's the final written address of defendant on the claimant. So case is adjourned to 5th day of June 2024 for adoption of final written addresses.
As God pleases, my lord. Dear God.
Yes, call the next case, please.
As God pleases, my lord. NICN/SK/16/2019. Atome Aqua Jonah and 3 others by MPF Microfinance Limited. My lord, I think is it third claimant, the third claimant in court, my lord, is in court, my lord.
Hold on, Gidado, hold on. Yes, you said the third claimant is in court.
Yes, my lord.
Okay, other claimants are absent.
Absent, my lord.
Okay, is that Zuera Haruna?
Yes, my lord. She's here,
all
my
right.
lord.
Okay. How about counsel? Defendants are absent.
Yes, my lord.
Oh, sorry. The defendant is a microfinance. Yes, any defendant representative? Gida, do any defendant representative?
Yes, my lord. Pardon?
I'm not saying counsel, not counsel representing defendant.
No, my lord, there's no any party, my lord.
All right, so appearance, please.
May you please, my lord? AA Ochidi.
AA who?
Ochidi. OCHIDI.
Oh, what?
CHIDI.
Okay, Ochidi, yes. For the claimants. Yes, Ochidi, who are you appearing for, please? Okay, thank you. How about defendant counsel?
Please, my lord.
Yes. Is it the same counsel that appeared the last time? You said Tijani Abubakar.
Tijani Abubakar. TAZANI.
Yes.
My lord, my appearance is for the defendant.
Yes, sir, counsel. Nashima is your device louder than it. Yes, sir, counsel. Ochidi. Yes, matter is for adoption. The final is yes, sir, counsel. Nashima, are you connecting? Try to connect. Yes, counsel. I can't hear you, please. Gidado.
Yes, my lord.
Yes, counsel, please. I can't hear you.
Yes, my lord, we are equally ready.
Okay, that's Abubakar.
Yes, my lord.
Yes, can you refer the court to the processes file? Yes, Abubakar, you are for the defendant. Yes.
Yes, my lord. My lord, the defendant filed its final written address dated 19th February.
It was filed on 20th February.
19th February, but it was filed on 20th.
It was filed 20th and dated 19th February.
Yes, my lord.
Yes.
My lord, the defendant formulated 4 issues for determination of this court.
Hold on, we have to check if we have the final written address here. It should be there because I've gone through the file.
Yes, my lord. The file,
yes, I have it. Yes, go ahead. Yes. Go ahead, counsel.
Yes, my lord. We filed our final written address.
Yes.
On the 20th February, 2024.
I have it before me.
Yes, my lord. We then filed a reply on point of law.
Yes, the reply was filed on 15th March 2024.
Yes, my lord.
Yes, sir, counsel.
My lord, the defendant formulated 4 issues for the determination of this honorable court.
Just hold on, counsel. Yes, sir. Councillor. Yes, I have you. You said you filed your reply on point of law. You filed your reply on point of law on the 15th March 2024. Councillor, Councillor, you still with me? Bring that one. Yes, this one. Okay. Defendant counsel. Yes, defendant counsel, are you still with me?
Yes, my lord.
All right.
Yes, my lord. We want to adopt the same as our final written address.
Yes.
And reply to the claimant's final address, my lord.
Yes.
And we urge the lordship to dismiss the claim of the plaintiff, of the claimant.
Yes.
And the grant declared in the counterclaim of the defendants, my lord.
All right.
Thank you, my lord.
Yes, sir.
Yes, my lord. The claimant's final written address is stated and filed on the 11th of March 2024.
Yes.
The claimant's final written address is stated and filed on the 11th of March 2024.
I have you on record already, counsel. Please go ahead.
Yes, my lord. We formulated 2 issues for determination. And we adopted the said claimant's written address.
Yes.
And legal arguments are therein.
Sorry, I can't hear you.
We adopt the claimant's written address.
Yes.
And all the legal arguments canvassed therein.
Yes.
And we urge the grant of relief prayed by against the defendant.
Yes, please.
Thank you, my lord.
Thank you. Yes, sir. Bashima, can you check the available dates for judgment? Taking into consideration the other, please, so there's enough. Yeah, in April. Okay, it can go for July. Or you have for June already. Okay, so check July, and that should be early July. Early July. Second, 02. Counsel, please check your diary for 2nd day of July. What day of the week is that? On a Tuesday, check your diary for judgment, 2nd of July.
Convenient, my lord.
All right, thank you. So the matter is further adjourned to 2nd day of July 2024 for judgment. 2nd day of July 2024 for judgment. Yes, Gidado, call the
Escort, please, my lord. NIC/SK/1M/2024. Tukur Mohammed Magani and 2 others by Zamfara State Government and others, my lord. So here is the application of the parties absent.
parties are absent.
Yes, my lord.
Any counsel?
Yes, my lord.
Yes, my lord.
Yes, counsel, I can see you. Please announce your appearance.
With profound respect, my lord, I am U.S. Abubakar for the claimant.
U.S. Abubakar.
Yes, my lord.
Yes, counsel. Any other counsel for garnishing?
Humility, my noble Lord, M.S. Suleiman, DCL, State Minister of Justice.
Hold on, please. Where is machine? Yes,
With utmost respect and humility, my noble Lord,
yes.
M.S. Suleiman, DCL, State Minister of Justice.
You are for the judgment debtor respondent.
Yes. And with me,
Okay.
yes, for the judgment debtors respondent.
Yes, counsel. Yes. Who are you appearing for? All right, first garnishing. That's UBA PLC.
Yes, my lord.
Yes, counsel. Please proceed.
Yes, my lord. The matter today for the first garnishing to your cause. My
yes.
lord.
Yes, my lord. First garnishing.
Yes.
Affidavit dated and filed on the 15th day of April 2024. The 18th paragraph affidavit.
Where is the affidavit? Where is Bashima? Where is the affidavit? We discussed yesterday. Where is it? Hmm? Where is it? Hold on, counsel. When did you forward this video? And why hasn't she printed it? Call me there. Let me see the one on the phone. Yes, you first garnish, you filed an affidavit when, please?
Filed on the 15th day of April 2024. A 18th paragraph affidavit with 5 annexures.
When was this filed? You said it was filed when? Where's is Gidado not there?
Yes, my lord.
Yes, can you help the court, please? Because you are seated there, and we have just the copy you sent
My
by
Lord, I filed an
electronically.
affidavit.
If you have it before you, please give us the information.
Yes, my Lord, she had filed an affidavit yesterday. So I sent a soft copy to Bajma. It was late when she filed it yesterday. But the
Yes,
original
if it
copy,
was just filed yesterday, we cannot take it now. Has it been served on the other party? On the
yes,
claimant, judgment creditor? Have you been served?
yes, all they had been served.
Let me hear. Are you the judgment creditor, the claimant? The judgment creditor, are you there? Counsel?
We have been served, my lord.
You have been served?
Yes.
So when was that filed, Gidado? You said yesterday. Yesterday was 15th.
It was yesterday, my Lord.
Yes, Abubakar.
Yes, my lord, we have been served yesterday.
Yes, so are you ready?
Yes, we are ready, my lord. We have filed a counter affidavit today, my lord.
Where's the real affidavit? Because this is the one for the judgment creditor. Please, something was forwarded to you. Why didn't you print it? What happened? Why didn't you print it? How can you escape your mind and have a matter to do? Going on and you say you didn't print it, you can escape your mind. Can I have it if it's on your phone or whatever? Let me have it. Yes, Ochidi. Ochidi, please proceed. Yes, counsel. Ganishi, firstGanishi's counsel.
My lord. We are just
Where is he? Yes, counsel, I can't hear you.
my lord, we are just prepared affidavit.
Yes. Please, can you start all over again? I could only hear you to the extent that you filed an affidavit on 15th of April. How many paragraphs affidavit?
18 paragraph affidavit. With 5
Yes.
lectures. 5 lectures marked as exhibit A to E.
Yes.
This reliance on all the said paragraphs of the affidavit.
Yes.
And all the honorable court to grant it as free. Thank you, my lord.
Yes. What's the name now? Abubakar.
Yes, my lord.
How many
My lord,
paragraphs?
upon receipt of the affidavit
18.
of the first garnishee, we file
Please,
a
can you
counter.
hold on? Can you confirm the paragraphs, please, to be sure that it's 18? Thank you. Yes, Abubakar, that's the judgment creditor.
Yes, my lord.
Yes.
Upon receipt of the first garnishee affidavit, we have filed a counter affidavit, my lord. dated and filed 16 April 2024.
Is that the one? No, not you. Dated and filed when?
16 April, my lord, 2024.
Yes.
My lord, the affidavit is 10 paragraph affidavit. The first two on behalf of the applicant.
How many paragraphs? It was deposed to by who?
By one Bello Ibrahim Ango.
So how many paragraphs?
On behalf of the applicant, my lord.
Bello who? Bello Ibrahim Ango. Yes, sir, counsel.
My lord, we place reliance on all the.
Yes, on behalf of the judgment creditor. Counsel, you said the counter affidavit is of 5 paragraphs, but we have 10 paragraphs here.
My lord, I said 10 paragraphs.
Okay, 10, not 4.
Yes, my lord, 10.
All right, thank you. Yes, please.
We place reliance, my lord, on all the paragraphs contained in the affidavit.
Yes.
Also, the tolerable court to deem the content of the affidavit as having been read.
Sorry?
We also the honorable court to deem the content of the affidavit as having been read, my lord.
Yes.
And we urge the honorable court finally to make the order nisi absolute.
All right, will that be all? Will that be all, counsel?
Yes, my lord, that's all.
All right. So give me a date for ruling. Can you check the diary so that it doesn't clash with any next case? Just hold on. Let's give you a date for ruling. As you follow, if you know it's not convenient, in case you have judgment. So if it's convenient, we can fix it. So fix it there. 5th of June. Okay, 5th of June, 05.
That's good, Mrs. My lord.
5. Okay. Yes, counsel, check your diary. It's 5th of June.
It's convenient, my lord.
All right, thank you. So the case is adjourned to 5th day of June 2024 for ruling.
That's good, please.
My lord, please, I have an objection.
Sorry?
Court, please.
My lord, I have an objection to the counter affidavit of the applicants, my lord.
Did you file anything?
No, my lord. I was served this morning in court.
Yes, counsel, why didn't you raise this issue before going ahead to...
I'm sorry, my lord.
You ought to have raised this issue. before going ahead to even proceed with your own I think you are Ochidi.
Yes, my lord.
Yes, you went ahead to move your own.
I'm sorry, my lord.
Yes, so what do you want now?
Yes, my lord. In order 52, 51 of the National Industrial Court rules, there is no procedure for the applicant to file a counter affidavit. There is nowhere stated 51, my lord, of the National Industrial Court rules 2017.
Hold on.
There is no specified for the applicant or judgment creditor to file a counter affidavit to the affidavit of the garnishee.
Yes, I'll put you on record all the same, counsel.
God pleases.
Hold on. I'll put you on record, yes. I will not expand you. Put you on record. That's Uchidi. Okay, I think that's the, is that the judgment? Now, what you mean, okay, yes, is that Abubakar is the judgment creditor. Okay, so you say you're objecting to the counter affidavit filed by the judgment creditor?
Yes, my lord.
Yes, and we rely on what or that what?
Order 51 of the National
of this court.
2017.
All right, yes.
Yes, my lord. There is nowhere it was stated that the judgment creditor applicant has the right to file a counter affidavit to the affidavit of the garnishee. So we urge this honorable court to strike out the said counter affidavit of the judgment creditor applicant.
I don't think that's it.
260. 260.
Will that be all?
Yes, my lord.
Okay.
Thank you, my lord.
So everything, but will they still retain that same date for the ruling, that 5th day of June 2024? I hope, counsel, you are with me.
I'm with you, my lord.
Yes,
I'm with you, my lord. Yes, my lord, in response to the counsel objection, my lord. My lord, there is nowhere in order 52 also that says the judgment creditor shall not file counter affidavit against the affidavit of the garnishee, my lord.
Yes, Abubakar.
Yes, my lord.
All right.
My lord, in order 51, as stated by the council, there is nowhere in the order.
You have said that. It's already on record.
Thank you, my lord.
Yes.
And it's a common practice, my lord.
Yes.
That wherever there is affidavit.
Yes.
There is always room for counter affidavit, my lord.
All right.
Yes.
Yes, will that be all?
Yes, my lord. I urge this honorable court to discontinuance with the submission of the learned counsel, my lord.
All right. Will that be all?
Thank you, my lord. That's all.
Okay, thank you. So the case is still adjourned to 5th day of June 2024 for ruling.
And what all is this?
Gidado,
My lord.
have you taken note of that date?
Yes, my lord.
All right. So I think that should be all.
For the Sokoto, yes, my lord. Thank you, my lord.
I think that is all for the day. So
Thank
court will exit the site, and thank you. We call it a day.
Thank you, my lord.
All right. Thank you.
Thank you, my lord.